advised, the Court of Appeals Division 1 is now in session.
Please be seated. Morning. We are here today for oral argument in the case of State of Arizona versus John David Rothrock, our case number 1CA-CR19-0388. We have conferenced the case, reviewed the briefs and the record, and we are very familiar with it, so we would ask you to keep that in mind in making your argument. This matter will be, I believe, live streamed and is being recorded and will be posted to YouTube. So when you speak, please identify yourselves and who you're representing so that the parties or people who are watching can keep track of that for us. Obviously, you'll stay at your counsel table for your argument. If you want to leave your mask on or take it off, I don't think we have any objections since you're pretty well spaced out right there. And when I'm done talking, I'm going to put mine back on, but that's up to you. I don't think there's anything that I've missed. I think we've covered it all. So with that, I'm sorry. Each side gets 20 minutes. If you want to reserve time, appellant, for rebuttal, you are free to do so, but make sure that you keep track of it yourself. I believe you can see the clocks from where you're seated.
I can see the clock.
Yeah. We don't police that for you, but if you want to reserve time, just let us know and then stop when you think you need to reserve some more time. All right, and with that, we will proceed. Thank you.
Thank you. Good morning. If it please your honors, my name is Larry Kazan and I represent the appellant, John Rothrock. I actually tried John Rothrock's case in front of Judge Fox. I've presented three issues for the court to consider on appeal. One involving the denial of an important witness that supported the defense theory of the case. A second involving denial of motions for judgment of acquittal as to a number of charges. And the third involving the application of an aggravating sentencing factor that, in my estimation, should not have been applied in this case. The remedies for each of those would be different. Dealing with the latter first, the remedy would be remanding this matter back to the trial court for resentencing. The middle issue, after a review by the court would either affirm or, if granting my request, would enter judgments of acquittal as to those counts. And finally, if the court ruled in my favor as to the issue regarding the denial of my ability to use Dr. Blackwood, the remedy would be to remand the matter for a new trial. I'd like to talk about the motions for judgment of acquittal first. It involved the statute 132904, disorderly conduct, and subsection 6 of that statute is unique in that everything in that statute is a class 1 misdemeanor until you get to subsection 6 when it becomes a class 6 felony, my estimation, because of the use of a dangerous instrument or deadly weapon as part of the information. In order to apply it to the facts of this case, since the instrumentality being used that supported these particular convictions was an automobile, which I know in the briefing it made it sound like maybe we were arguing that a vehicle, an automobile, is not a dangerous instrument. I don't take that position. I don't mean that. I can't tell you how many vehicular offenses I've tried. I know that an automobile is a dangerous instrumentality. But the language of it wasn't discharged and it wasn't displayed. So the only way that this statute would potentially apply to the facts of this case would be the manner in which it was handled.
Is there a specific definition of that phrase in the code?
No.
And so, I mean, not to, but don't we say, oh, the car handled well? I mean, everybody and their mother refers to driving a car as handle. Why wouldn't we say that's pretty much typical phraseology as it relates to the statute?
Your Honor, I respect what you're saying. However, if you read that language in conjunction with the other language in the statute, it doesn't seem like the legislature meant to include this type of factual scenario. And I say that because they gave some specific, they confined it to those three types of uses. If they wanted to apply it across the board to any activity, then why wouldn't they just say a person commits disorderly conduct by recklessly using a dangerous instrument or deadly weapon? I mean, then you can apply it to any time a deadly weapon or dangerous instrument is utilized recklessly. I don't think that's what their intent was when they enacted the statute. And I say that because there are so many other laws that preclude this kind of behavior. We have a reckless driving statute that deals with the reckless disregard of the safety of persons or property. We have the crime of endangerment, which is another Class 6 felony, which can be alleged dangerous just like this one could, where somebody recklessly creates the risk of serious injury or death.
Yeah, but Mr. Kazan, that's never been the standard. My goodness gracious, you could pick any illegal act and say it can be charged 500 different ways.
And I agree,
Right,
Your Honor,
I mean-
but I think that goes to the legislative intent of what they meant to cover in this kind of statute. And I believe that the intention of this statute was for purposes of mishandling a weapon of some sort, like a gun or a knife or something along those lines. And I don't think they meant it to be used in the situation of the recklessly operation of a motor vehicle. The state talked about handling a horse. Well, you don't drive a horse, and you don't operate a horse, you don't steer a horse. And in the operation of an automobile, there's much more in play than just your hands. You're using your foot, you're using your head, your eyes. So I just think that, I think that it was improvidently used here.
But counsel, even if we follow your argument that the correct meaning and understanding is that which refers to managing with the hands, and you say in your brief that it reflects the legislature's intent only to penalize conduct involving dangerous instruments that are capable of being managed or held by the hands. But aren't the hands managing a vehicle? Isn't it by the use of our hands that we get it to move to one place or another?
I would say that is a component of the entire driving operation, but there's more to it than just management with your hands.
Well, from the perspective of the body, what the body does in interacting with the vehicle, it's primarily the hands. There's the feet also, of course, but...
Well, if you wanted to look at recklessly, I mean, you could be managing the vehicle with your hands, driving straight ahead, but with your feet pressing down on it, on the accelerator to go at a greatly unreasonable speed. So your hands wouldn't really be playing a role in the reckless operation. Your feet would be, or your head, making the decision to do that. So
Did you ever find any case law or anything in the legislative history in which a court or the legislature has expressed what you're asking us to find? In other words, that we meant this to be a narrowing definition instead of a broadening definition.
I did not find that anywhere in terms of legislative history. I will say that there were some unreported decisions from the Court of Appeals that allowed the use of this statute in driving or operation of a vehicle scenario. So I was aware of that. I think they're wrong.
Any unreported cases that support your position, though?
No.
Okay.
And then factually, in terms of was there enough evidence to convict my client of this offense, the way the facts lined out, the intent to disturb the peace and quiet of the particular persons, and the indictment in this case was, and I shouldn't I've never written an indictment, so I wouldn't know how to write one, a good one or a bad one, but in this particular instance, all of these different charges with respect to the 5 police officers that were in the one police vehicle that were the victims of this offense, each one of these counts just says, my client with the intent to disturb the peace and quiet of the person, neighborhood, or individual recklessly handled, displayed, discharged an automobile. And then they added the dangerousness allegation where they said that it was dangerous because of the use, discharge of an automobile or serious physical injury inflicted on, and they listed the particular police officers' names. That being said, and that I guess is how you would differentiate between which count applied to which person. But I guess the point is, at the time Mr. Rothrock's behavior that gave rise to these particular offenses occurred by driving on the wrong side of the roadway. The evidence showed that the reason that he did so was because in the northbound lanes of traffic on Mill Avenue, traffic was backed up because a police officer had stopped it. And in order to circumvent that, he, in the middle of an intersection, crossed over and went on the opposite side of the raised median and was traveling northbound in the southbound lanes. He was already doing that and in that position when the driver of this law enforcement vehicle turned from 5th Street on to southbound Mill Avenue. They turned and he was there. And as soon as they turned and they got into his path of an already traveling the wrong way on the roadway, he drove around them. So I don't see how the evidence, even when you view it in the light most favorable to the prosecution.
I'm not following why it matters that they turned, because they took a legal turn into the direction that they were supposed to be driving on.
Well, if his intent was to recklessly drive with the intent to disturb their peace and quiet, he already was doing that before their peace and quiet came into play.
But why does the turn matter? Wouldn't it be the same if they just happened to be coming down that street and he had done it, but before they could see him?
If they were already coming down the street when he did that, then I think they're in play. I think the fact that he was already in motion on the wrong side of the street, driving recklessly, I don't think that he would have any intent when he made that.
He wouldn't have known that they were coming? Is that your point?
He wouldn't have known they were coming. He didn't see them coming.
But isn't it just reckless conduct to do that in the first place?
I think it is, but it doesn't each of these offenses require that he have that particular intent with respect to these particular people? It wasn't just general intent to disturb the peace and quiet of the neighborhood. They charged it with the intent to violate the peace and quiet of these particular people.
But when you do something like that, don't you run the risk that there's going to be an innocent bystander? I mean, it doesn't seem to matter to me that these were police officers in the area. I mean,
without a doubt, and I think it could have been charged as one count that said, with the intent to disturb the peace and quiet of the neighborhood, he recklessly operated his vehicle in this particular manner. If handle works. So I think it could have been charged that way. I don't think that it should have been charged this way. I mean, frankly, this should have been, not that it would make any difference because the punishment would be the same. It should have been charged as endangerment because that's really what he did.
Counsel,
Yes.
before we run out of time, I'd like to hear you touch on the issue of Dr. Blackwood and the fact that he was not permitted to testify. I find that to be an interesting issue. Thank
you, Your Honor, I feel guilty that I spent that much time on that particular issue. I know that I was accused of trying to use Dr. Blackwood to argue diminished capacity to the jury. But that was never my intent to tell the jury that because Mr. Rothrock was an impulsive individual or that he made bad judgments when he was in stressful situations, which is what Dr. Blackwood would have helped me with. He would have also helped me with talking about suicide based on his dealing with suicidal individuals and how sometimes they would want to follow through on it and sometimes they wouldn't, and how they were conflicted about it. And he could have given some very helpful testimony that would have actually helped fit in with what my police procedures expert Roger Clark talked about in terms of suicide by police officer.
Isn't that just the motive for the crime?
I'm sorry?
Isn't that just the motive for the crime? His motive was, I'm going to engage in this behavior so that somebody will shoot and kill me.
Well, certainly that was a possibility, but as it played out, Your Honor, it seemed like while he wanted to kill himself, he didn't follow through on it. And a lot of people on the jury could have been thinking, was his...
Well, how is that a defense to the crime?
Well, I don't necessarily believe it was a defense to the crime, but it certainly could have...
So it
the
goes to
jury.
his motive, and maybe he had a bad motive, but it
might
had
have-
nothing to do with the fact that he was engaging in intentional conduct, did it?
Well, I don't think that... I mean, isn't
I
it...
mean, to
isn't
find
it
this relevant, you have to explain to me how it is relevant to the particular crimes charged. And the only way I get there is for you to say, well, no, it was diminished capacity.
and I...
Because there's clearly motive evidence, but there's other evidence of motive in this case.
But I don't think that I wasn't planning on using it for diminished capacity. I was using it to show, number one, that a lot of people are going through bad situations in their lives, like divorce, like he was, and they don't want to kill themselves. So the impulsiveness of his decision to do so was consistent.
Oh, we're right back to diminished capacity.
I'm sorry?
We're right back to diminished capacity. You're
Well-
not telling me he's not intentionally engaging in conduct or he's not knowingly engaging in conduct. You're saying, oh, it was diminished because he was being impulsive.
I actually was not saying that his intent wasn't diminished. I was saying that
So you're conceding that he intended to do his conduct.
yes, I believe that
Well,
he...
then why are we here on that issue?
Because I think that Dr. Blackwood could have provided information on people that are suicidal. I think that he could, and I mean...
But suicide, what does that provide the jury?
Well, it would give the jury the idea that Mr. Rothrock's purpose on the roadway that night wasn't to cause a bunch of problems with police officers. I
That
mean,
he
it was
had a
really pretty
different
unusual
intent.
circumstances when you think about it. I mean, here's a businessman traveling from Yuma to Colorado, and he just happens to be driving through Phoenix, and all of a sudden gets involved in a 39-mile chase in a shootout with police. I mean, for a man who had never been in trouble before, I mean, it really is an unusual set of circumstances that the jury should have been aware of what was going through this man's mind. We allow character evidence, and these, I mean,
Yeah,
I
but
know that
you're-
the cases talked about
You're trying to
behavior.
offer an expert to testify as to what was in his mind.
I wasn't offering an expert to testify what was in his mind at the time. I was
Well, I mean, but that's what you
offering,
just told us, is the jury needed to hear what was in his mind, and you're complaining about the expert was not permitted to testify.
I'm sorry, what I was trying to say was that I wanted the jury to know that this man had behavioral tendencies of acting impulsively.
And what's that relevant
to whether or not he was truly intent on killing himself.
But you just told me about 2 minutes ago that he was engaging in intentional conduct. The intentional conduct, which was the underlying basis for this crime.
Well, that's the prosecution's argument, Your Honor. I
No,
certainly
that's
wasn't
what I
going to
asked
be.
you, and you said yes.
Well, in terms of candor to the tribunal, Your Honor, do I believe what
No, and I
that should?
appreciate that, but I'm just saying, the other fact that he may have an alternative motive for engaging in the intentional conduct doesn't mean that it's still admissible, even if it was, because it was motive. Are you
Well-
telling me there wasn't sufficient evidence in this case that would indicate what his motive was for engaging in this intentional conduct?
I think that there was some evidence of that, but if you're saying
Isn't that what
that,
the
then why
state
did,
argued?
why
Didn't
was,
the state argue this was a suicide by cop?
and I know because they said in their opening statement, shouldn't I have been allowed to talk about that or present somebody to talk about that?
Well, it wasn't in dispute. Why should we allow additional evidence? You said it was suicide by cop. They said it was suicide by cop.
Well, they said it first in their opening statement, so why couldn't I present evidence to support what we talked about? I mean, if they brought it into issue,
But you wanted to have specific evidence of his impulsivity. which seems different than whether it was suicide.
Yes,
or
I did
combat.
want the evidence of
That-
impulsivity.
I'm
And-
having a hard time distinguishing between impulsivity and diminished capacity.
Yeah, I mean, first of all, I wish Christensen would have never been decided, because that's thrown this whole world of diminished capacity into upheaval.
Mr. Kazan, we are monopolizing your time, and it's 1:30 left, so I assume you want to save the rest for a rebuttal.
I know, Your Honor, I do want to talk about that one last issue on the aggravating circumstance.
Go ahead then, I'm sorry.
And I'm going to be brief on this. The way this offense was charged in terms of aggravated assault on a police officer with a gun, dangerous, it was already aggravated from a Class 5 felony to a Class 2 felony because of the use of a gun in terms of aggravated assault on a police officer. It became dangerous, again, because of the use of a gun. And the charge of placing someone in reasonable apprehension of physical injury is the same as threatening somebody.
But the jury had to find the additional aggravator of serious physical injury, which is an
Well,
additional.
And the language in the indictment said physical injury with a gun. So how could you possibly have physical injury, the threat of physical injury with a gun, and that not be serious physical injury if a gun or a deadly, dangerous instrument is something that is used for lethal purposes? So, I mean, it is under 701D. I mean, it was already being aggravated because of the use of the gun. Count 1, the jury didn't find that aggravating factor because the gun was shot in the air. Counts 2 through 5, the jury found the aggravating circumstance because the police officer was shot at.
What you would want it to, which is to look at the evidence and determine whether there was risk of serious physical injury or not in this case.
Right, but I guess the point is the use of the gun automatically makes it serious physical injury. How could it not be? How could you use a gun at somebody and not have a threat of serious physical injury?
Appreciate your time, Mr.
Thank you, Your
Kazan.
Honor.
Thank you. Ms. Claw, is that it?
Yes, Your Honor. Good morning, Your Honors. May it please the Court, my name is Grace Cynthia Claw, and I'm here on behalf of the appellee, the State of Arizona. This Court should affirm Rothrock's convictions and his sentences, and deny his claims on appeal for 3 reasons. First, it was proper to preclude Dr. Blackwood from testifying, and it did not deprive Rothrock of his right to present a complete defense. Second, it was proper to deny the Rule 20 motion because the state had presented substantial evidence to obtain the convictions. And 3, the sentences for counts 2 through 5 were aggravated based on a valid aggravating factor that was not an essential element of the crime. If the Court does not have a preference in the order in which I'm going to proceed, the state will begin with the proper preclusion of Dr. Blackwood. The state, there were 3 categories of evidence about which Dr. Blackwood was supposedly going to testify. It seems based on the argument today that what defense counsel below had wanted to do was to have Dr. Blackwood testify about the general characteristics or behavioral traits of suicidal people in general. However, that would not have been admissible under Rule 404A because, 1, the behavioral trait evidence has to be based on personal observations, and it cannot be based on, it's not a generalization of how people behave in society. Any behavioral tendency evidence has to be specific to the particular defendant at issue. And here, if the evidence was proposed to be used in order to give expert testimony about general characteristics of suicidal people, that would not be permissible under Rule 404A. In addition, that type of evidence would not have been allowed under Rule 702 because Dr. Blackwood admittedly had no expertise in the area of suicide or suicidal people. And he also, specific to Rothrock, did not evaluate him for suicide or his suicidal condition or depressed state of mind. And just on and as the judges touched upon, yes.
In going through this work, was Dr. Blackwood's report ever offered in evidence?
Not for appeal purposes, no.
There's no offer of proof, there's reference to it in the pleadings, but is there a specific place that if I want to go look at it, I could go look and say, here's the report?
Not in the record on appeal, no. The defense did submit the report and Dr. Blackwood's resume to the trial court, but once the preclusion ruling was delivered, there was no offer of that information for appeal purposes. So all we have on this record are references and quotations to that particular report and the trial court's references to the resume. So to answer your question short, no, there's no place we can go to look at it. And as to the offer of proof, we argue that the argued proof was not sufficient in order to establish the relevancy of the evidence with regards to the impulsivity trait. Although defense counsel made conclusory comments about Dr. Blackwood giving testimony about...
You would deny that it's relevant to the motive for this crime, are you?
It may go to his motive, but it has no relevancy to the actual charges. I mean, the motive itself
I thought the motive was always relevant.
Motive is relevant, but it doesn't have a tendency here to negate any of the charges. But again, just to finish the answer with regards to the offer of proof, defense counsel, when he actually got the chance to make his offer of proof as to why evidence of impulsivity was not relevant, he did not mention impulsivity whatsoever. At the hearing itself, he only talked about essentially what opposing counsel today spoke about was about Dr. Blackwood supposedly offering evidence about suicidal people in general and how they're conflicted and what might be going through their minds. So at that particular hearing, defense counsel did not actually talk about how the trait of impulsivity would be relevant either to this case or to his claim of attempted suicide. And just on a different note, the state's brief did touch upon a little bit about even if we were to move forward past the offer of proof question and look at the specific testimony that Dr. Blackwood could have offered with regard to behavioral tendency evidence, that particular evidence, based on what we have on this record, would show that any testimony he would have provided would have constituted diminished capacity evidence because his evaluation was a Rule 11 proceeding, which essentially goes down to whether a defendant has a mental disease or disorder that would affect his understanding. But also he was a neuropsychologist, and based again on the quotations that we have in this record, he evaluated Rothrock mostly with regard to Rothrock's physiology and his neurological functions, and there's very little reference in this record to any behavioral opinions he could have offered. So with regard to that, the state does not believe, the state argues that any evidence of the trait of impulsivity was irrelevant. It was not relevant it was not a pertinent character trait, and therefore it was inadmissible under Rule 404A. Moving to the state's second point, the Rule 20 motion was properly denied. That particular motion was concerning only the disorderly counts the disorderly
Counsel, you
conduct.
would agree that it is interesting, if not compelling, that the way in which the disorderly conduct statute is written is different than other areas in which we look to whether it's a deadly weapon, dangerous instrument. Well, specifically the use of, as opposed to other statutes which define it and talk about a deadly weapon, dangerous instrument. It does specifically talk about handle and display, as opposed to other statutes where that's not narrowed. It's not so narrowed as it is in the disorderly conduct statute.
Okay. Well, in that regard, yes, it would be considered different. However, we don't feel that would exclude the...
But what is the purpose then of having a statute that narrows it down to display and handle, and I'm drawing a blank on what the third one is? Discharge. Where you don't use that in like aggravated assault with a deadly weapon, dangerous instrument. So why is it different here?
I can't say as to why the legislature chose to not use the word use. However, when you do look at the entire statute, it's recklessly display or discharge a dangerous recklessly handle, display, or discharge a deadly weapon or dangerous instrument. Arguably, the use of display and discharge relates specifically to a deadly weapon, since that's something you would primarily, those are verbs primarily attached to it. But the fact that
You'd agree you couldn't display a car in a threatening manner, right?
No, we agree with that, but that's why we also have the or in that particular provision that allows us to
The
use.
display does not have to be relegated to a firearm. You could display a knife.
That's correct, yes. But
So-
to the deadly weapon portion of that particular provision, I think you can use display or discharge. But because the provision also refers to a dangerous instrument, that arguably, yes, you can still display and display a dangerous weapon or a dangerous instrument, I'm sorry. But handle itself, we believe that the legislature intended to use it, intended that term to have its plain meaning, which is not, the state doesn't disagree that the plain meaning would be to manage with your hands. Where we disagree with opposing counsel is the hands-only restriction that he imposes. We believe that that's too impractical and unreasonable, and it would exclude the use of other dangerous instruments that the legislature intended could constitute a dangerous instrument.
So I'm sorry, it sounded to me like you conceded that handle means with your hands?
Yes, but not exclusively. So we don't disagree that the term can be managed with your hands, because you can still manage a vehicle with your hands. It doesn't matter, though, that you also have to use other body parts like your eyes.
If you
and your
strapped a
feet.
dangerous instrument to your foot and tried to kick someone with it, could that be still handled?
No, but that would fall under recklessly discharge. So that would fall within the provision.
No, I said dangerous instrument, so discharge,
Oh.
I think you said would be a gun, probably.
Probably, yes.
But you've got a dangerous instrument, not a deadly weapon, and you strap it to your foot and try and kick someone with it. Could that be handled? Or would that not be disorderly conduct?
Potentially, yes. If you take, for example, a skateboard or a surfboard or a snowboard, you can still use that object, and you're not using your hands at all. But you can
So
still
if you like
disrupt
kick turned
someone's
it
peace.
and launched it at somebody, that could still be handling that skateboard.
Correct. Like you could kick a soccer ball and disturb someone's peace. Just again, it would have to constitute would fall within the definition of a dangerous instrument. But in the hypothetical with a surfboard or a snowboard, those definitely could constitute a dangerous instrument, and it's something that you can handle and disrupt someone's peace with, but it doesn't require the use of your hands.
And you would say a snowboard is handled with your feet.
Right, you handle a snowboard, you handle a surfboard. So the state believes that it's not problematic to define handle as to manage with your hands, but we do disagree with imposing a hands-only restriction on that. And again, I'd just like to remind the court that in our brief, we did note that the definition of to handle, the source for that particular definition gave as an example a horse. And I've personally ridden a horse, and I don't know if any of you guys have, but it does require your feet, and it does require the use of your body weight as well. So, but the dictionary did give as an example of to manage with your hands to ride a horse. And we would argue then that plain meaning doesn't imply or it doesn't intend for us to impose a hands-only restriction when we're saying we're going to handle something.
Why, do you have any evidence in the legislative history or case law or anything to explain why the legislature used such narrowing terms in disorderly conduct but didn't use them in aggravated assault, for example?
No, I didn't.
Counsel, can you address Rothrock's argument with regards to sentencing and threatening infliction versus placing another in reasonable apprehension of physical injury?
Yes, and that's my third and final point. The aggravator was a valid aggravator, and essentially it sounds like what opposing counsel is arguing is that the aggravator constituted an element of the crime because you cannot think of a scenario where you would have committed a crime without having committed the aggravator also.
How could you threaten someone with injury with a gun without also threatening them with serious physical injury?
An example would be pointing a gun in the air. You can point a gun in the air, it would go off and the person nearby, that arguably would constitute the crime of aggravated assault for placing a bystander in reasonable apprehension of imminent physical injury. But because you didn't point the gun at the person, arguably they didn't actually threaten the person with a serious physical injury.
So it's the threatening that's the difference, not in your scenario, your hypothetical, it's the fact that he didn't threaten him with the injury as opposed to the degree of the injury.
Yes, and that is something that we also discussed in our brief, that the potential for harm that it's involved in the crime element is something of a lesser degree. The state didn't have to prove that the potential for harm in there was a serious physical injury, but for the aggravator, it had to.
So I guess you could also posit some extreme hypotheticals of a defendant who says, hey, point the gun at you, but don't worry, I'm a really good shot. I'm just going to nick you. I'm only going to hit you in the shoulder. And maybe the guy believes him and says, well, I wasn't really that afraid he was really going to hurt me, but I did think he was going to injure me. I guess that would be another possibility.
That would be another example, yes. So,
but we get a little kind of crazy when we start going to such extremes, don't we?
you do, and again, that misses once we start going down that road, it misses the point, because the dispositive question here isn't whether you can have one scenario without also having the other. The dispositive question is whether what the state had to prove for the aggravator, did that constitute an essential element of the crime? And in this case, the state did not have to prove that Rothrock threatened a serious physical injury. They only had to prove that he performed an act that placed the victim in reasonable apprehension of imminent physical injury. And again, as we had briefed, the potential injury that the state had to prove was only one of physical injury, not serious physical injury as the aggravator requires, but also that for the purposes of the aggravator, the state did not have to prove that the potential injury was imminent, whereas it had to prove that the potential injury for purposes of the crime was imminent. And for those three reasons, the imminence, the seriousness of the injury, and the act itself, act versus actually proving what type of act, the threat, for those reasons, the aggravator was not an essential element of the crime. And so aggravating those sentences for those three reasons was appropriate. And if this court does not have any further questions, we ask the court to affirm Rothrock's conviction and sentences.
I don't have any questions, Judge Cruz?
I do not.
Judge McMurdy? All right. With that, we will take the matter under advisement and issue a written decision in due course, and we are at recess. Thank you.
Thank you.